Our framers told the states to resist unconstitutional acts of the federal government. Our framers saw resistance, nullification as a natural right, not a constitutional right. Some nullification deniers say states may not nullify anything the federal government does because nullification is not a constitutional right. Well, of course it is not a constitutional right. Rights don't come from the Constitution. Rights come from God. You're here. As Jefferson, Madison, and Hamilton said, nullification is the natural right of self-defense which predates and pre-exists the Constitution and the federal government. So the natural right of nullification, transcending as it does the Constitution, and being nowhere prohibited by the Constitution to the states, is a reserved power. In Federalist number 45, Madison says, the powers delegated to the federal government are few and defined, and all other powers are reserved to the several states. So it is the federal government which is supposed to look to the Constitution for the list of enumerated powers we the people delegated to it. The states don't go to the Constitution to look for permission because they retain all powers they did not exclusively delegate to the federal government. Or prohibited themselves in Article 1, Section 10. The nullification deniers pervert our Constitution. They permit the federal government to ignore the limits on its powers as enumerated in the Constitution, but insist the states can't do anything unless the Constitution says they can. What is interposition? A state interposes when it stands between the federal government and the citizens of its state in order to protect them. Interposition takes various forms depending on the circumstances. Hamilton says in Federalist number 33, if the federal government should overpass the just bounds of its authority and make a tyrannical use of its powers, the people whose creature it is must appeal to the standard they have formed and take such measures to address the injury done to the Constitution as the exigency may suggest and prudence justify. Did you hear what Hamilton said? When the federal government usurps powers, we are the judge as to whether there is a violation, and we decide what we are going to do about it. Nullification is one form of interposition. Now listen carefully because what I'm about to say is so difficult to understand that none of the deniers get it. Our framers saw that before nullification is proper, the act of a government must be unconstitutional, a usurpation of a power not delegated, or a violation of the Constitution. Matthew Spaulding at Heritage Foundation and David Barton don't get this one. Before nullification is possible, the act must give an order. The states or the people can refuse to obey or otherwise obstruct or sabotage. Randy Barnett and Robert Levy of the Cato Institute don't get this one. Here are examples where refusal to obey an unconstitutional law or opinion is both proper and possible. Rosa Parks and Martin Luther King nullified the Jim Crow laws. These required black people to sit in the back of the bus. They couldn't eat in public places, use public restrooms, water fountains, and park benches. Using non-violent civil disobedience, Rosa Parks and Martin Luther King led black people to refuse to obey these state laws or municipal ordinances, which were unconstitutional under Section 1 of the 14th Amendment. This is how brave citizens nullify unconstitutional laws. They say, we won't comply. Prayer in the public schools. The Constitution does not delegate to the federal government power to ban Christianity. But in 1962, the Supreme Court started ordering the states to stop the praying and remove the Ten Commandments. Since these orders were usurpations of powers not lawfully possessed by the federal government, the states should have nullified them by directing their schools to ignore them. Disarming the American people. If Congress by law, or the President by executive order, or the BATF by rule, or the Supreme Court by opinion, or the federal government by UN treaty, orders the people to turn in our arms, we must refuse to comply.
We will!
The Constitution does not authorize the federal government to disarm us, so the states and the people must nullify such law or order or rule or opinion or treaty by refusing to obey. All nullification requires is a spine. Example where other ways of resistance than direct disobedience were appropriate. The Kentucky and Virginia resolutions of 1798 objected to the Alien and Sedition Acts, which purported to grant to the president dictatorial powers over aliens and seditious words. The states could not refuse to obey the acts because they were directed to the powers of the president. So the resolutions showed these acts to be unconstitutional and asked other states to cooperate in taking whatever measures needed to be taken to defend the Constitution, the states, and the people. During 1799-1800, Madison, who wrote the Virginia resolutions, presented his report on the Virginia resolutions to the Virginia legislature. In this report, Madison said, under his discussion of the third resolution, which is the heart of the 8 resolutions, and I'm condensing what he said. The states, in their sovereign capacity, are the parties to the Constitutional Compact and are thus the final authority on whether the federal government has violated the Constitution. There can be no tribunal above the authority of the states to decide. The compact made by them has been violated by the federal government. That if, when the federal government usurps powers, the states don't stop the usurpation and thereby preserve the Constitution, there would be no relief from usurped power. This would subvert the rights of the people as well as betray the fundamental principle of our founding. That when the federal government acts outside the Constitution by usurping powers, then the sovereign states, who are the parties to the Constitution, must appeal to that original natural right of self-defense. That the judicial branch is as likely to usurp as are the other two branches. Thus, the sovereign states have as much right to judge the usurpations of the judicial branch as they do the legislative and executive branches. That all three branches of the federal government obtain their delegated powers from the Constitution, and they may not annul the authority of their creator. And if the judicial branch connives with other branches in usurping powers, our Constitution will be destroyed.